afternoon and welcome to the third in our series of webinars. It's really good, 3 weeks and we're already at exchange of contracts, which I think is a great deal faster than most of us managed during the conveyancing process. But for those of you who have been with us all stages, thank you very much for carrying on. We've been very pleased to work with you on these webinars and to see numbers attending going up week by week. So remember to reserve your place for next week's one. Well, I won't give the game away, but I think it probably is something to do with completion, but we'll see. We've had some very good feedback from you, and also thank you all for taking the time to answer the questionnaires, which we've put at the end of the sessions. This has been very useful for us in seeing what further products we can help you with, and also where training requirements are needed. Today's questionnaire does have a couple of questions regarding land registry delays, because we have been doing some work with Ian and with the land registry to see if there is an insurance angle which can help you where there is a substantial delay in registration. So we've put a couple of questions about that in there to see your response, and hopefully in the not too distant future we may have a product which can help you. It won't solve it entirely, but may well give you a way to ensure that you can transact a property which is caught by registration. Housekeeping today, as always, if you have any questions, can you put them in the questions or chat box, please? The handout is available. You can draw that down now. Otherwise, as always, we will be sending you the handout, copy of the slides, and a link to a recording a couple of days afterwards. We need to take a couple of days for them to make Ian look more attractive and young. That does take a while, so but that should be out by the end of the week. So anyway, enough of that. Ian, if you're ready to go, please start.
Thank you. Never mind a couple of days, Robert. I think you need months and a bit of I don't know what it is, a bit of photoshopping or whatever to make me even more remotely presentable. Anyway, good afternoon everyone and welcome. Robert was saying a few things there. First of all, yes, doing a very exciting project with regard to applications for first registration, and Robert won't know this, but I've just was dealing with the underwriter this morning, and I've been looking at the sort of draft policy and policy wording, etc., which is really exciting, to be honest with you. So do keep in contact with Robert about that. As I say, it's early stages, very embryonic, but we're getting there. The other thing, as Robert mentioned, is that Stewart titles support these events, and they've been very, very popular, which I'm delighted about. But also Stewart Title are keen for the profession to say to them, and hopefully involving me, hey, can we have some training on other issues? So that line of communication is open and will remain open. I know we're looking at the feedback from the last couple of events. There's lots of interest in all sorts of different courses, but you know, you need to feed me and feed Stewart Title with what you like, and then we can see what we can do for you. And the final thing, before I sort of delve into the mysteries of preparing for exchange of contracts and exchange of contract itself, is to be aware of our residential conveyancing forums. Robert and I and the team at Stewart Title have residential conveyancing forums, support staff forums, commercial property forums, all manner of different things, and they're brilliant. And the thing I like about them is that we have a pool of expertise in connection with attendees who are willing to share, guide and assist. So it really is good fun and very, very good value. It's 60 minutes of your time. They are recorded, but you learn things, or if you've got a burning question, you can put the question to the forum, and it's amazing how frequently there'll be answers, solutions, or indications as to where you can go for answers and solutions. So enough of all that. Let's get down to the nitty-gritty with regard to preparing and exchanging contracts. As far as preparing for exchange is concerned, in the time that I spend dealing with title insurers, dealing with professional indemnity insurers, and dealing with the profession, the big issue for all of us is time and having time to look and think. And therefore, the most important thing as far as the conveyancing process is concerned, whenever there are key steps, exchange of contracts, completion, etc., give yourself time just to do a quick audit of the file, your case management system, just to check that everything is in order. One of the things that I love conveyancers to do, and I love case management systems to have, is some form of issues page or outstanding issues page. And I would always suggest that when we're preparing for exchange, have a look at that to see if there are any outstanding issues. We might be waiting for a copy of an amended plan. We might be waiting for a page of planning conditions. We might be waiting for the seller to respond to an unsatisfactory response in a TA6 or TA7 form. I'd much rather have the time and look and check to see what's outstanding, and then either, if I've got time, chase up the outstanding issue, or alternatively advise my client that that issue is still outstanding and asking the client if they're happy to proceed notwithstanding. And again, as far as reporting on title is concerned, a report on title should be issued to a client before exchange of contract, and I want the client to see it in good time so that they can digest it, confirm to me it's been read, understood and digested, and then inviting the client to raise any questions or queries and building in time to deal with those questions and queries. So that's the important thing that I think. So preparing for exchange then, fundamental points I've just discussed. We're going to look at acting for the seller and acting for the buyer. We'll talk about procedural issues and good file management. When acting for a seller, there are a number of things. One, if we haven't already got redemption figures, I would say let's get them before we exchange contracts. Let's see that we're going to have sufficient funds to enable to discharge any charges. Let's also see if there are any notices on the title that require removing, that we can actually deal with their removal, and that we're comfortable with the form of undertakings that we're providing, or we're comfortable that the interest in land to which the notice relates is going to be extinguished or terminated before completion. The next thing that we ought to do is just check our TA13 form. If it hasn't been completed, it's probably prudent to complete it and get it off to the other side in readiness for completion. And I'm a great believer in doing sort of as many things at the same time on a file as is possible. So there might be other things that, again, to speed up the transaction might be useful, that might be considered steps to take after exchange, but we might sort of bolt everything together before exchange, things like obtaining estate agents' accounts, preparing our bills, preparing any other charges or interest that are going to be discharged involving the payment of money. We've got a dependent purchase. Of course, it's necessary to have a look to see the status of the dependent purchase. Where we are exchanging on a sale and not exchanging on a purchase, so we're not looking at synchronization between two transactions, I would warn the seller before exchange on the sale about the potential danger of exchanging and then our purchase falling through, for example. Just a sort of cautionary note for the client. We're acting for the buyer and we're preparing for exchange. Again, issues. Are there issues that are outstanding? If those issues are outstanding, are they going to be dealt with before we exchange? If they're not going to be dealt with, are we comfortable that they're going to be capable of being dealt with before we complete? Again, if I'm acting for a buyer, I would always have a look at the title and assess whether or not there are notices on the title that are going to be removed. If so, what's the seller's intended course for removal? If there are notices remaining on the title, have I adequately explained to the client to what sort of interest in land those notices are protecting? And a word of caution, restrictions. If there are restrictions on the seller's title, am I going to be able to comply with those restrictions after I've completed the transaction? Again, the clock is ticking towards completion. Outstanding restrictions could cause me a real headache if I complete and then find out I can't comply with them after that event. Acting for the buyer, again, submission of accounts to the client, pre-completion searches we might think about. Of course, from a convenience perspective, we look at post-completion activity and pre-exchange activity, pre-completion activity as sort of separate blocks. But I'm fully aware that most conveyancers will be doing as much as is possible at each individual stage. So again, we might be undertaking some of our pre-completion activity before we exchange contracts, just because it is timely to do so. As far as procedural issues are concerned, some of the things that we need to talk about when we're acting for the buyer: the issue of insurance. Is the buyer going to insure? Can the buyer insure? To what extent are we going to want the buyer to provide us with evidence of insurance relating to the property? And again, when we're preparing for exchange and we're acting for the buyer, the position with regard to the deposit. We need cleared funds, obviously, in order to facilitate exchange. Good file management involves an audit. I know some firms will have someone else in the team auditing a file. Others will have some form of case management system or some form of AI doing an audit. I don't care what you do as long as someone is casting an eye over the file, or in circumstances where you are the sole person who is handling the file, again, as I mentioned earlier, just taking time out and having a look to check if everything is in order, if any outstanding issues require addressing, to make sure my client is fully au fait with what's happening with regard to the transaction. As far as the contract itself is concerned, again, we should all audit it and check the position. Who are the parties? How is the property described? Has my client inspected the property and have any issues arose relating to that inspection? We've confirmed that we're happy with the seller's title. We know the purchase price. On the issue of deposit, have we told our clients about the way the deposit is to be held? Does our seller know about their vulnerability in accepting a reduced deposit? Does our buyer understand that if our buyer defaults on completion, a real sort of double whammy in that obviously he'll be unable to complete the purchase, but also he'll be obliged to pay over the balance of the deposit that was due. So if we've paid a 5% deposit, we then default at completion, we're obliged to pay the balance, a further 5%, notwithstanding our inability to complete. Does our buyer client appreciate the inequity with regard to that concept and the difficulty that it will create? As far as contents are concerned, the TA10 form should be annexed to the contract. We need to make sure our client has read it. I would like my client to have signed the TA10 form, and I'd like my client to understand the position with regard to apportionment of purchase price, where fixtures, fittings, etc. are allowing the purchase price to be apportioned as between those items and the purchase of the property for SDLT purposes. Watch out for two things with regard to the content of the contract where we're buying a property that's a buy-to-let property. Had an email yesterday from someone who was buying a property, it was being sold as a buy-to-let property. The nature of the tenancy as described in the contract was not the same as the buyer's understanding of the tenant and the tenancy that had been explained to him by the seller, and that was as described in the agent's particulars. I've had problems with this in the past where I remember a client of mine bought a property on the basis that the property was being sold subject to a short hold tenancy. The client bought the property and then found out the tenant did in fact have a lifetime tenancy. Now, all right, in that situation, you're going to say, Ian, what's the problem? We can sue the seller for misrepresentation or misdescription. The answer to that is yes, you can. However, the downside is we're stuck with a tenant for life with regard to a property, whereas we thought there was an assured short hold tenancy that could be brought to an end fairly swiftly to the advantage of the buyer. So be careful with vacant possession. Other points with regard to vacant possession from a practical perspective. Let's assume we've got a great aunt that's living in the property, and great aunt is referred to in the contract, has signed a copy of the contract to confirm she'll provide vacant possession at completion. Be alive to the fact she may well have signed the form, may well be quite prepared to provide vacant possession at the date of signing before we exchange contracts, but circumstances could change, meaning that at completion, on the basis that the great aunt, our imaginary great aunt, can't find alternative accommodation, she may just decide to stay put and create a nuisance for herself. In those circumstances, might we want, where we've got any doubt as to the genuineness or otherwise of someone in occupation, might we want them to actually vacate and to have proof of vacation before we exchange? And again, I really worry when I'm dealing with civil partnership disputes, matrimonial disputes, that sometimes occupation of the matrimonial home or a willingness to vacate the matrimonial home all of a sudden becomes a pawn in connection with another dispute concerning children, concerning maintenance, etc. So if in doubt, if the property is being sold with vacant possession, but we've got a tenant in occupation, with a party in occupation, I may want that party to be removed and the contract to include a special condition to that effect at exchange of contract. It means then I don't have to worry about something going wrong between exchange and completion, meaning that our imaginary third-party occupant has some form of card up their sleeve that they can play, generating a nuisance for themselves to the advantage of them as opposed to the property owner or another third party. So do be careful about all of those things. Finally, before we exchange contracts, as we're preparing for an exchange of contract, are we comfortable that both part contracts are the same? And here's a very important point. If you've had a situation where whole rafts of special conditions are being inserted or new clauses agreed, having had discussion, make sure that each part contract mirrors exactly the other part. Because if it doesn't, there's an argument that the clauses that don't mirror are unenforceable, and potentially the entire exchange of contract is void for non-compliance with Section 2. So this applies with regard to changes to wording. It also applies to documentation that's annexed to the contract. So we need to do an audit to check that everything is in order. Where new conditions, special conditions are being agreed or inserted, either a new contract is prepared in full by the seller and it's executed by the parties in the normal way, or where special conditions are added, side letters, etc. utilized. One, if we're using side letters, make sure the contract refers to the side letter and the side letter refers to the contract. Two, if we're changing wording, make sure that you see what the other side has inserted in their part contract and show them what you've written and check the two are the same. So what I'm talking about here is a situation where we've just inserted another whole series of special conditions. I would want to make sure that what I've handwritten on the contract is the same as exactly the same as what you've written on the contract. And what I'm likely to do is scan my part contract with my handwritten amendments and ask you to do the same, email them across to one another and just check that they are the same. Watch out for particularly special conditions referring to conditional contracts. Be careful where you're drafting anything that is complex or with complex wording. I repeat the point that if you're using a side letter, make sure the side letter refers to the contract and the contract refers to the side letter. And my final word with regard to content of the contract, and again, I just saw a problem relating to this last week. If you include a special condition that's inconsistent with a standard condition, which prevails? Well, unless you specify in the contract which prevails, neither prevails. Excuse me, and they cancel one and each other out. So be careful with regard to that. Okay, so let's move on then. Acting for the sellers. Have we got authority to exchange? Interesting point. In law, if you're instructed to act for a seller, then it's implied that you have authority to exchange when it's safe to do so. I would always want written authority from the client to exchange. That written authority could be emails. Remember what I bleat on about in connection with co-owners. They're not a collective client. So if we're acting for Mr. and Mrs. Smith, we want Mr. and Mrs. Smith to give us authority individually with regard to an exchange. Something I haven't mentioned on slide, but something I do want to mention today. Have we got authority to release a contract if we're acting for a buyer, for example? Again, the new draft Law Society Code for exchanging contracts emphasizes the potential problems associated with a release of a contract. We'll talk about that a little more when we talk about acting for the buyer. Position on a dependent transaction, again, just warn the client where the client is saying, look, I'm happy to go into temporary accommodation and we'll complete our purchase at some point in the future. If I haven't exchanged on a dependent purchase, I need to email my client and warn them of the potential of the purchase falling through and our client having nowhere to live. Good advice might be, let's back off with regard to the exchange on our sale and let's synchronize an exchange on our sale and purchase so that horrible eventuality does not occur. Is the client happy with the proposed completion date, and are we happy as well? Again, given what I've said about building in time to do reviews and audits, is that going to give us sufficient time to do all that we can? Be particularly careful with regard to new builds and exchange, because there will be some flexibility normally in favour of the builder with regard to when completion takes place. We need to make sure that we're not putting ourselves in a difficult position with regard to an unreasonable timetable being imposed on us. Again, acting for the seller, this last point, if there are notices on the title, are they remaining on the title? Are they being removed from the title? And if so, what is the method of removal? If we're giving an undertaking with regard to the removal of notices, say relating to second charges, etc., are we comfortable with the process and with the wording of our undertaking that we're going to give? Refer back to the TA13 form for that purpose. And can the buyer comply with restrictions? Now, I know you're all sort of shouting at me, Ian, it doesn't matter. I'm acting for the seller. Whether the buyer, solicitor or conveyancer can comply with the restriction is of no consequence to me. But I would say it is of consequence to you for the following. One, I think that the conveyancing process is collaborative. Just looking again at LinkedIn, and boy, oh boy, are conveyancers and solicitors get it in the neck, left, right, and centre. And, I do feel sorry for frontline conveyancers because they've got a horrible job made worse by third-party interference. But at its heart, this is a collaboration process. And therefore, in the spirit of the conveyancing protocol, in the spirit of collaboration, I don't want to send my buyer under a bus by allowing them to complete and then finding out there's a restriction on the title that's problematical. Further, if a buyer does have a problem with regard to a restriction, that problem could come back and haunt me, in that the buyer may only be able to remedy the position with some form of involvement or assistance from me, in which case my seller client is unlikely to be prepared to pay the additional costs that are expended as a consequence of the time that I spend to try and assist the buyer out. So I think we do need to do that audit. We do need to check the file and make sure that if there are restrictions, the buyer can comply. If the buyer can't, or if we think there's an issue, then we've got to flag that up and tell the buyer about the steps and measures we could take or that they can take, so that the restriction issue is not an issue post-exchange or post-completion. Acting for the buyer, again, have we got authority to exchange? And have we got authority to release a contract? And does the client understand what a release of contract does? Last week, I had an email from someone about this who was saying that their client was arguing that they were not aware that a contract had been released for 2 hours and was not aware of the potential problems associated with that release. The major problem being, of course, that during that 2-hour period, control with regard to exchange vests in the seller. So does a client understand that? Have we got authority? Is the authority in writing? Is the authority to facilitate a release of a contract for a particular period of time? And are we aware that that's the period of time only that we can release? And again, with regard to release and with regard to authority to exchange, I would always, with a buyer client, explain to the buyer client the process and explain to the client when we will be notifying our buyer client that contracts are exchanged. The next point about, is the buyer going to insure? Well, again, this can be a difficult issue and a conundrum depending on the transaction. But where the client is going to insure, I, being very cautious as far as conveyancing is concerned, and my caution arises due to claims, I would always want the client to provide me with evidence that they are able to insure at exchange of contract, and I would want the client to be aware of how the exchange will take place and who is going to notify the buyer client of the need to put the policy on risk. The next thing, searches and searches in order. Again, I talk about searches all the time to members of the profession, and I explain a number of things. One, searches do not necessarily carry any form of priority, nor are searches guaranteed to be accurate. Do they need refreshing? Well, let's just drill down on this point. They would need refreshing in circumstances where you are told something that would mean there's been a change in situation or circumstance, or new information is available to the buyer client or their surveyor that would warrant a fresh look at a search. So we undertake an environmental search and report that comes back clean. Our local land charges search reveals that the local authority's register of contaminated land has listed the parcel of land that we're acquiring as being contaminated, or our surveyor or valuer says, well, hang on a minute, I'm not sure about this. From previous surveys and knowledge of the local area, there has been some contamination that's migrated onto part of the site. Again, in those circumstances, client, there's an issue here, search report from our environmental team comes in clean, everyone else is sending alarm bells. Let's do another environmental search and report. Local land charges, inquiries of local authority, additional inquiries or supplemental inquiries of local authority, neighbour or TA forms advising about a planning application, discussion with a buyer and neighbour reveals some planning activity that's just come to light. Then again, new searches, new inquiries might be appropriate. We could also have a situation where there's a significant delay between receiving instructions, undertaking searches, and then exchange of contract, in which case, the client should be advised that it may be prudent to refresh the searches that were done originally. Yes, there's a cost consequence, but the client might find out, or we might find out, information that is necessary for the client to have in front of them when authorizing us to exchange contracts. So searches, again, it's a question of drawing to the client's attention that when we're doing the searches, the fact these searches have a lifespan, and being aware of circumstances where that lifespan expires, and being aware of the fact that they may need refreshing. If they are refreshed, are there inconsistencies between original search and new search, and have we reported to the client? Again, identifying risk and identifying issues. Mortgage offers. What is the mortgage offer? What are the terms of the offer? Again, as I've mentioned to you, you don't explain the basics of product, but you explain risk to the client. Risk of default, problems associated with non-compliance with mortgage conditions, interest rates, fixed and then variable, penalties, all of this sort of thing, I think should be dealt with in the report on title. The survey. Have we read the survey? Again, I come across firms from time to time that say we don't read surveys or valuations. You've got to, because the surveyor or valuer may spot an issue relating to title that you would be expected to investigate. Again, where our client has not heeded our advice with regard to type of survey, I would want in my report on title to remind the client that I recommended a level 3 survey and explain to the client the reasons why, and then say, but despite that, you've proceeded to purchase the property on the strength of a valuation. And again, just remind the client that the valuer may be doing his or her job thoroughly, but will not be as thorough, will not be as complete as a surveyor undertaking a level 3 survey. Again, some firms will attach the survey to the report on title to the client. Again, that's a matter for you. I think just be careful about information overload. If we are producing a final report when we've completed all due diligence, is this going to be such a huge document that important messages are being lost? Or are we going to produce interim reports on title where we are sort of advising the client as stages are met during the due diligence process of what we found? Deposit and cleared funds, again, practicalities, and explaining to the clients the vulnerability of that deposit in connection with buyer default. Now, again, what I'm saying to you is really conflicting with what I said earlier about information overload. But I want my buyer client to know that if the buyer is unable to complete or unwilling to complete or has a change of heart post-exchange of contract, the deposit that has been paid or is required to be paid is vulnerable to being lost. It is not automatically lost, as we'll see when we talk about completion next week, but it could be lost as a consequence of buyer default. So now let's talk about the exchange process. And what is an exchange of contract? Well, an exchange of contract is the creation of a legally binding agreement that is compliant with the Law Property Miscellaneous Provisions Act 1989. It is possible to transfer a beneficial interest in a property without a formal exchange or without the transfer being in a proper legalistic format. There's case law that can show you that an exchange of emails will be sufficient to transfer a beneficial interest. But with regard to a contract for the sale or purchase of land, there is a requirement to comply with Section 2. As a consequence of that, we've got to make sure that our contracts mirror one another, as we've said. We've got to be particularly careful about variations to the contract. We need to understand that we could have one contract that the parties sign, and we could also have, and may well see in the not too distant future, contracts that are retained electronically and signed by our clients electronically. So the Law Society's draft code for exchange of contract envisages, as I read it, some form of exchange platform where the contract sits and where the parties execute it within that platform electronically. But currently, we've got a written document with the need for wet ink signatures. As far as variations to the contract, as I say, ideal world, the new contract is redrafted and executed by our clients, or alternatively, oral variations are agreed, contracts amended or side letter created in the way and subject to the conditions that I mentioned a little earlier. Assuming all is well, assuming that our contract does not require any form of variation, assuming it's been properly signed by our clients, we're ready to exchange. Before I go to the next slide, however, there's a point I want to note. Are you, as a solicitor conveyancer for a buyer, authorized to sign a contract on behalf of your client? And again, this case law suggests, yes, you have an implied authority to sign a contract on behalf of a client where your client authorizes you to do so and where it is safe to do so. But I would be really wary about signing a contract on behalf of a client, because theoretically you are personally liable under that contract. Personally liable to complete, personally liable for potential breaches. So I've seen this in the context of a limited company client where a solicitor has executed a contract on behalf of that client where the client no longer existed due to being dissolved at company's house. Solicitor was therefore personally liable under that contract and had exchanged to purchase a very valuable piece of land. As a consequence, if you are going to sign a contract on behalf of a client, I'd want written authority. And if the client was a limited company, I'd want to do a company search just to confirm the company is still in existence before being willing to proceed on that basis. As far as methods of exchange are concerned, we currently have telephonic exchange as being the predominant method. There are some advantages with regard to a telephonic exchange. There are also some significant disadvantages. Advantage, major advantage, as close as we can get to synchronization on dependent sales and purchase. So we exchange contracts on our sale at 2:21, immediately put the phone down and exchange on our purchase at 2:22. That 1 minute interval between the two exchanges has the potential to be a doomsday disaster scenario by us receiving a telephone call from solicitors or our client to say they don't want to proceed or can't proceed, but that's about as good as we can get unless we have a release. With regard to Formula A and Formula B, important to make sure who's holding the contract, to make sure the contract has been signed, that if there are any variations, they've been agreed and client's approval obtained. As far as a Formula B exchange is concerned, this is by far the most common, where each party's solicitor or conveyancer holds the contract on behalf of their client. There is then a telephonic discussion about exchanging contracts, culminating in an exchange, culminating with both sides putting contract in the DX system or in the postal system that day, and funds for deposit being transmitted by the buyer's conveyancer to the seller's solicitor or conveyancer, or going to somewhere up the chain as a deposit in connection with seller's purchase, etc. With regard to the methods of exchange, a few things to mention. One, a memorandum of exchange, or the box at the top of the contract on the face of the contract, needs to be completed carefully. If there are any changes to the contract, any variations to the contract, or any variations to undertakings that are given relevant to the contract, again, it's important that that is noted. If I exchange contracts with you and I'm not sure about your trustworthiness, I may well email a memorandum of exchange to you after we've exchanged, just to confirm that I've made a contemporaneous note of all that's been said and done during that exchange process. Other points with regard to methods of exchange: in exchanging contracts, you are giving undertakings on the part of your firm. The most obvious undertaking being an undertaking to transmit contract to the other side's solicitors that day. So you need authority to do that from your firm and, of course, from your client. And where an undertaking is given, it is essential that the undertaking is complied with. If we're exchanging now and completion, we're exchanging contracts now and the post has gone or the DX has gone, we should be ensuring that our exchange is subject to the fact that the contract will not be going in the post or DX system today. It'll be held to your order pending completion, or going in the post or DX system tomorrow. If you are exchanging contracts on behalf of a firm, whether acting for seller or buyer, there are implied undertakings. The implied undertaking when acting for the buyer is that the deposit will be transmitted to the seller or deposited elsewhere, depending on what's been agreed. As far as synchronizing exchange is concerned, again important, I always work on the premise that I'll exchange on my sale and then exchange on my completion. And therefore, if I want a release of a contract, I want the solicitor or conveyancer acting on my sale, in other words, the buyer's solicitor or conveyancer, to release their contract to me. I need to be aware that any buyer's solicitor or conveyancer releasing a contract will want to do so for a shorter period of time as possible, but also I need to understand and appreciate the practicalities of attempting to exchange in connection with a long chain. So the period of release is going to be dependent on the size of the chain and the availability of the parties, solicitors or conveyancers effecting exchange. Again, I refer to the New Law Society's Code for Exchanging Contracts, which refers to the fact that if you are authorizing or permitting a release of a contract, there needs to be someone available at the firm that's releasing the contract to accept a telephone call or communication to confirm exchange has taken place. And again, if we are releasing a contract, that availability needs to be addressed and dealt with. Important. Other things that we need to have a think about relating to synchronization of exchange of contract and exchanging contracts generally, it is imperative that as soon as we've exchanged contracts, we let our client know, email, text or telephone call. Important that where we have exchanged contracts, that's confirmed in writing. Where a contract has been released, but the release has not led to an exchange, our client should be contacted as soon as the release period is at an end to advise that the transaction release has not been successful or fruitful and that an exchange has not taken place. Promise me that where you had a client's authority to release a contract for say 30 minutes at 1 o'clock this afternoon, and it's now 1:30 and we haven't exchanged and the release period comes to an end, that we contact our client and tell them where a new release is to be agreed a little later this afternoon. Again, client's authority provided. Don't assume that just because the client has authorized a release for 30 minutes at 1 o'clock, that can be expanded to facilitate a release at some point later in the afternoon. All things being equal, it's unlikely to be a problem, but it could be a problem at some point in the future. Okay, the next thing I want to talk about is assuming we've exchanged, assuming our client has been notified, we need to think about protecting the contract. And when we talk about protecting the contract, what do we mean and what is to be protected? Well, on an exchange of contract, the buyer acquires an equitable interest in the property, courtesy of an estate contract. That equitable interest or estate contract can be protected by a notice in the charges register of the seller's title, or it could be protected by a C4 land charge, assuming the land is unregistered. Where I have a valid exchange of contract, therefore, I can protect the contract if necessary, which begs the question, when would you protect the contract? Well, I'll give you my sort of list of scenarios where I think a contract should be protected. Number one, where you have the slightest inkling that the other side solicitors or the other side, as in their client, can't be trusted. Because theoretically, a seller could exchange contracts with more than one buyer. Obviously, completion is going to be impossible for all concerned, but theoretically, we could exchange contracts today and then exchange contracts on the same property tomorrow. Number two, where there is likely to be a long delay between exchange and completion. Now, here you're all saying, Ian, what's a long delay? I would say that certainly anything beyond 6 months after exchange before we complete, I would think about protecting the contract. 3 months, I'd be thinking about protecting a contract where I wasn't sure as to the status, medium to long term, of the seller. So what do I mean by that? I'm exchanging contracts on a purchase and Persimmon Homes are the builder developer. In those circumstances, I would say, unless I'm going to be completing 6 months hence, I wouldn't worry about protecting the contract, unless I read that Persimmon Homes are in financial difficulty. On the other hand, I'm exchanging contracts with a local builder, XYZ Builders of Northampton, a small limited company that I don't know. If I was exchanging and completing sort of 3 months after exchange, I might think about protecting that contract. Very interesting point, very important point to share with you. Where I was buying off plan a flat or an apartment, again, from either a relatively obscure or unknown builder developer, or I knew I was buying off plan and deposits were being utilized to fund construction, I'd probably contemplate protecting the contract immediately, where I had a situation where completion was likely to take place at, say, a month or beyond the date of exchange. Why would I be so jumpy about that type of scenario? Well, I can share with you some case law. 2 cases in the last sort of 18 months or so, both highlight the same point. One, if you're buying a flat or an apartment off plan, then on exchange of contract, you acquire an equitable interest in the airspace where your flat or plan or property would be situated. The builder or developer goes into liquidation, or the builder as an individual goes into bankruptcy, then the trustee in bankruptcy or liquidator is likely to want to realize the asset, the plot, where the works are being commenced or are to be commenced. If you've exchanged contracts with regard to plot 5 on the 6th floor and you've protected the contract, then if the liquidator or trustee in bankruptcy wants to sell the building or the plot or the site, he would have to buy out your contract, and he would do that by giving you your deposit back. If, on the other hand, you hadn't protected the contract in those circumstances, the deposit would just fall within the general bankruptcy or liquidation, meaning that your client would be a general creditor and would get the same as other general creditors, something like a penny on the pound or something of that nature. As I mentioned already, unregistered land you protect with a C4 land charge. With registered land, you'd protect with a unilateral notice or an agreed notice. Note the comment that I make with regard to the slide here. Agreed notices afford far greater protection than unilateral notices because unilateral notices can be challenged and agreed notices can't. Agreed notices can be cancelled by application to the land registry or to the court, or could be withdrawn by whoever has lodged the notice in the first place, but they can't be challenged. So unilateral notices are more vulnerable than agreed notices. You might find builders, developers and property owners will always preclude the registration of an agreed notice on a registered title for that very reason. If it's on the title, it's going to be hard to remove. Whereas if the title is burdened by a unilateral notice, that unilateral notice could potentially be subject to challenge and relatively easily removed. So whenever you're thinking about protecting an exchange of contract, think about using an agreed notice. With an agreed notice, the land registry will allow you to register it or to note it on a registered title in circumstances where the registered proprietor consents, or where the registered proprietor is an applicant, or where the land registry are satisfied as to the exchange of contract, the interest in land that's been created. So you could send an AN1 with a copy of a contract and a copy memorandum of exchange, and the land registry will allow an agreed notice to be lodged on the seller's title, even though the seller has not consented to that noting on the title. You don't need the agreement of the registered proprietor for an agreed notice to be lodged on a registered title, is the point I'm trying to get over. So do think about protecting the contract. So in summary then, let's just have a look at this. Has everyone understood the important point? Building in time, undertaking an audit, having a look at your contract, seeing if there are any special conditions that need inserting or variations to conditions, having a look at your TA13 form and looking at the seller's title. Are there notices on the title and how are they going to be dealt with? Are there restrictions on the title and are we comfortable that they can be dealt with? If we are going to push ahead with regard to a transaction, let's think about post-exchange, pre-completion activity before we exchange contracts. Make sure that we've got client's authority, that the client understands what we're doing. Now, again, here there's an important point. When we're onboarding clients, I think we should be explaining the conveyancing process in outline. We should be highlighting to the client the documents they will be encountering as the procedure progresses, and what the client needs to understand with regard to that documentation and how it will be used. So in this context, the client needs to understand that at some point before an exchange of contract, the client is going to be asked to read and sign a contract. The client isn't going to be bound simply by signing it, but it will be necessary to be returned to the solicitor for the seller or buyer in order to be used when contracts are exchanged. The client, I think, should be forewarned that it may be necessary to amend the contract or to add special conditions or to change special conditions depending on circumstances. I think it's prudent for a buyer to understand about the need to pay a deposit and the need to insure the property at the point of exchange of contract. I think it's also important to explain to the client that before exchange, the client's authority will be required and the client's confirmation required as to the content of the report on title and the client's confirmation that the report on title is acceptable. We need to audit and check if there are outstanding issues. Where there are outstanding issues, are we simply saying to the client in the report, there are issues that are outstanding, you've told us that you're happy to proceed? Or if there are outstanding issues, explain to the client that it's not safe to exchange contracts until those outstanding issues are resolved. I haven't mentioned much about lenders, but again, where our client is a buyer and where our client is buying with the assistance of a mortgage, it's important that we check lender instructions before we, on receipt of instructions and before we exchange contracts. And again, if there are revisions to our instructions, we need to be able to confirm before exchange that we're going to be in a position to comply with those variations to our instructions. All of these things require careful consideration. I don't want someone varying a contract 5 minutes before they're due to exchange. I don't want someone ringing a client up, say we're due to exchange at 3:30 this afternoon, and to be explaining to the client on the telephone a series of important amendments to the contract. Because in those circumstances, how am I going to get confirmation to the client in writing about what's being proposed, and confirmation back from the client in writing as to their happiness to proceed? Which leads me on to another point, attendance notes. Again, don't know if you've seen this, but Howden Insurance Brokers produce a quarterly newsletter about claims. The last one was in July. And in it, one of the things they say is conveyancers and solicitors fail to record or note clients' instructions, clients' authority to proceed, clients' awareness of variations to the contract and a willingness to proceed, clients' awareness and understanding of advice that you've given, but client then confirming notwithstanding they're happy to proceed with whatever. All of these things. So, for example, you know, the buyer's solicitors being told by the seller, the estate agent and the seller solicitors, look, you know, we need an exchange of contract today. We appreciate that you're still waiting for some search results, etc., but why not some form of conditional exchange? Well, again, clients need to be warned about the dangers of a conditional exchange. One, we need to make sure the client understands that the conditions must be clear and unequivocal. And two, if they're not, then the exchange of contract could well be unconditional, unfortunately. Okay, what I'm going to do now is just open up and see if we've got any questions or anything in the chat. So we'll just have a look at the questions to start with. And there's nothing there that I can see to date. But remember, as Robert was saying, if you have any questions or queries, feel free to put them in the box. I'll have a look at the chat as well. So can I just ask people, there's nothing there. Number one, are you all aware of the undertakings that you give when you exchange contracts? And are you comfortable that you as a fee earner have the authority to give those undertakings? Number two, do you warn your clients about reduced deposits? Seller and buyer need to understand the significance. Number three, how do you deal with insurance? If you're acting for a buyer, do you just tell the client you need to insure, or do you ask for proof? Number four, do you check lender's instructions before you exchange? Number five, if you're acting for more than one buyer, do you want each of them to confirm that they've received the report on title and they've read it and understood it? These are all very, very important points that you need to understand and appreciate. Okay, if we're protecting a contract, how many people here would use an agreed notice rather than a unilateral notice? And would anyone think about using a restriction rather than a notice to protect a contract? How many people have a sort of rule of thumb as to when a contract should be protected by way of timing, sort of 3 months, 6 months or something of that nature? So again, lots of interesting questions. No one answering anything or raising anything as yet. So I'm just going to go back and have a look. Nothing in that question and answer. Let's have a look in the chat if I can. See if there's anything there, and there isn't. Okay, what we're going to be doing next time is having a look at preparing for completion and completion itself. While we're waiting and to see if anyone's got any questions, have you looked at the draft code that the Law Society has produced with regard to exchanging contracts and the new form of protocols for the release of a contract and immediate exchange, etc.? Have you seen that? I've deliberately steered clear of it. It was supposed to be introduced in June of this year, but with the furore concerning the TA6 and everything else, it's been put in the long grass from what I can gather. You're all familiar with the fact that the climate change report guidance from the Law Society is out for consultation. I'm told that that's going to be live and active at some point, either December or January next year, subject to what the consultation reveals or generates.
Hi, Ian, it's Robert. Sorry to interrupt. We have got one question through.
All right.
Fatima has asked if you could please explain the contract rate provision in the contract.
Yeah, happily. Yeah, okay. Fatima, great question. Sorry about that. I didn't deal with it. Okay. The idea behind the contract rate in a contract is a means of identifying loss or damage sustained as a consequence of breach. So Fatima, at 3 o'clock this afternoon, we exchange contracts. I'm on the sale, you're on a purchase. We agreed to complete on Friday. The contract rate in the contract will normally be the base rate plus 1 or 2% of the seller's solicitors' bankers. So we bank with Barclays Bank. The contract rate is 1.5% over Barclays Bank base rate. Friday comes along, Fatima, you can't complete. Mortgage offer withdrawn, lack of funds. Your client promised you that the balance of the purchase price would be in your client account on Thursday. There's no sign of it. Okay. The position is that if you default with regard to your contractual obligation to complete, your client is obliged to pay my client contractual interest. Now, it might be that we said in the contract the latest time to complete on the day of completion is 2 o'clock. It's now 2:30 on Friday. Theoretically, Fatima, I can ask your client to pay a day's contractual interest. If completion doesn't take place until the following week, every day where completion does not take place, contractual interest would arise on the amount of the purchase price that was due to be paid. In other words, purchase price less deposit. So let's assume that there was a £100,000 purchase. You paid a £10,000 deposit. I would be able, or my client would be able to claim contractual interest on that £90,000 unpaid purchase price for every day until you complete it. Now, the important thing, Fatima, is your client can claim, or sorry, I could claim on behalf of my client, contractual interest or the actual loss that my client sustained as a consequence of your client's inability to complete. Now, normally what will happen is that if your client can't complete on Friday, I may well then serve a notice to complete on your client, giving 10 working days to effect completion. Your client then completes on day 9. My client would be entitled to 9 days contractual interest on the unpaid purchase price, the £90,000 divided by the contract rate and divided by 365. So the idea behind the contract rate is a penalty for your client's inability to complete. Okay, a number of things with regard to that penalty. The moment that a deposit exceeds 10% and a buyer defaults, the courts tend to say that's a penalty and is unenforceable. Secondly, with regard to contract rates, you need to check if you've got a sale and purchase. On your sale, you might be claiming contractual interest at 1.5% over Barclays Bank's base rate. But on your purchase, on a new build, you might be paying contractual interest at 5% above Lloyds Bank base rate. In which case, if your sale can't complete, you're going to claim contractual interest on our imaginary £90,000, Fatima, but your client is going to be paying contractual interest at 5% over Lloyds Bank base rate in connection with their purchase. Given that most clients buy upmarket, the deposit on the purchase and the unpaid purchase price on the purchase is likely to be far more than the money that your client is due to in connection with the buyer's default on your sale. Hopefully, Fatima, that explains that. So the idea of contractual interest, if the buyer defaults or the seller defaults and can't provide vacant possession, you are obliged to pay a percentage calculated by the rate in the contract on the unpaid purchase monies until completion takes place. Where completion cannot take place, where a notice to complete expires or where a buyer simply can't complete, then a seller will normally claim well, one is likely to forfeit deposit and bring a claim for damages for actual loss that they sustain. But the contractual rate of interest is a convenient way of compensating an innocent party where a defaulting party does not complete and cannot complete on the time contracted to complete. And it will arise and money will be due from the day of completion until the date completion takes place. Thanks for that, Robert. Any other questions?
We've had a few, Ian, but we'll just have time for one, which is, I think, an interesting one. Emily says that I note that Ian says, as a fee earner, you have authority to exchange, and asked, can a legal secretary carry out an exchange?
The point I was making, Emily, was this. Normally, you'd get written authority from your client to exchange contracts before you exchange, okay? Some firms will, in the retainer, say, you authorize us to exchange contracts when it's safe to do so, etc. I advocate that before you exchange contracts, you remind the client of your request for authority and get authority again. But where you, by mistake, did not have authority, then the fee earner, theoretically, as a fee earner acting on behalf of the client, has implied authority to effect the exchange on the client's behalf. My guess is a legal secretary would not have the same implied authority. But Emily, there's another point there. If you're a legal secretary and you're conducting exchanges of contract on behalf of clients, you need the firm to authorize you to give the undertakings that are required when contracts are exchanged, relating to the dispatch of the contract to the other side and where you're acting for the buyer, the payment of the deposit. Hopefully that answers Emily's question. Any other questions, Robert, or are we out of time?
We do have a few more questions, but perhaps we'll add those to the next residential property forum.
Right.
We'll send everyone today details of that, and then we'll look at some, because there are some interesting ones here about rising out of the points you've made. So we'll pass those over to that forum, which is in a couple of weeks. I think the next one, isn't it, Ian? We'll confirm the details and send out to people. But in the meantime, thank you for your excellent contribution as always, Ian, for leading us through these minefields. Thank you to everyone for staying on and listening to it, and for the questions we've had at the end. Join us next week for completion. And have a good week, and we'll speak to you soon. Thank you. Bye.
Thanks very much. Take care, everybody. Bye-bye. Bye-bye.